for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We're a national construction document service. Today's webinar is conducted by the wonderful Alex Barthet, a Florida construction lien law expert. Today's webinar topic is New Year, New Rules, Lien Law Tune-Up Workshop. So without further ado, I'd like to introduce the fabulous Alex Barthet.
Thanks, Jessie. Again, my name is Alex Barthet. I am a board-certified construction attorney here in Florida. And today we're going to talk about the lien law and bond law rules so that you don't make any mistakes in 2026. And as always, we will answer any questions that you have at the end of the webinar. You should have the GoToWebinar chat box on your screen. Please make sure to submit your questions. We will get to them at the end. Do not include the names of any people or companies in your questions. All right, so what are we going to go over? We're going to go over the lien law rules. It's very important that you understand how the lien law works to determine whether or not you have lien rights or not. We're going to talk about bond claim rules. So if the job is bonded, either a public bonded job or a private bonded job, we'll go over those rules. And then we'll talk about some collection tips, how to get paid faster to increase your cash flow and make 2026 a great year. As I mentioned, we'll answer any questions that you have. So let's get right into it. What are the lien law rules? So let's start by understanding who can and cannot lien a job. So if you are a sub, or supplier, you want to understand if you have lien rights on a job. If you're a GC, you want to understand not only what your lien rights are, but you want to understand whether or not the people that you hire, if they assert a lien or threaten a lien, are they right? So let's understand who has lien rights. So laborers. This is not a labor supply company. So if you hire a staffing company to show up and do general labor or cleaning, they are technically a subcontractor. What this means is labor, like John Smith the carpenter, not John Smith Carpentry Inc., John Smith the carpenter who shows up on your job as an individual, he has lien rights on the job. Now, again, it does not mean the employee of the shell contractor as a person doesn't have lien rights. It's very rare that we see actual laborers having lien rights or asserting liens, but just know that they do. Architects, engineers, and land surveyors, those are all deemed professionals, and as professionals, they have lien rights for the professional services that they render. Contractor. So the lien law defines a contractor as someone who is in privity, someone who has a contract with the owner. So the scope of work I may perform may be plumbing, but if I have a direct contract with the owner of the property, then I am considered a contractor under the lien law. So I have to follow all the rules as a contractor. So understand, under the lien law, it's not contractor as general contractor, it's contractor as in whether or not you have a direct contract with the owner. Subcontractors have lien rights. Those are people that are in contract with the prime contractor. Subcontractors, and then material suppliers and rental companies, whether they have a contract directly with the owner, with the prime contractor, with the subcontractor, or a subcontractor. So the material supplier to a subcontractor is the lowest rung in Florida that has lien rights. So if I am a subcontractor and I rent a piece of equipment, that rental company of mine has lien rights and has to follow all the rules that we're going to talk about. So who doesn't have lien rights? Material suppliers to material suppliers. So if you produce materials, provide materials to another material supplier who then supplies it to the job site, you do not have lien rights, but the material supplier that ultimately provides it to the job site does. So where we see this sometimes is, if you order switchgear from an electrical supply house, maybe GE, who manufactures the switchgear, doesn't have lien rights, but the supply house that has the direct contract with the sub or the sub or the contractor or the owner, they have lien rights. Or sometimes we see rental companies for maybe shoring equipment rent amongst themselves. So one shoring equipment rental company will rent product to another shoring equipment rental company who will then rent it to the job. That first shoring rental equipment company does not have lien rights on the job, but the second one does. And the other group that doesn't have lien rights is subcontractors, right? So subcontractors do. So for example, you have an owner, a contractor, the mechanical subcontractor, that's the subcontractor, and then maybe a metal ductwork subcontractor. That that party has lien rights. If they buy materials from a supply house, that material supplier has lien rights. If there's a rental company that they rent from, they have lien rights. But if they subcontract out labor to now what would be considered a subcontractor, that subcontractor does not have lien rights. So what are the steps in order to record a lien? So step one, no later than 45 days from your first work, you need to serve a notice to owner. This does not apply if you have a direct contract with the owner. So if you're a prime GC, a subcontractor in scope, but you have a direct contract with an owner, you do not need to serve that notice to owner. I recommend that you do. It's a great collection tool. Owners that get it will take you a little more seriously, especially if they're residential owners. It gets you on the release list, meaning when you send a notice to owner to somebody, you are now typically put on a list of people that they need to ensure they get a release from. So they're not going to pay someone until they get a release from you because you sent a notice to owner. So getting that notice to owner out is a great collection tool. Step two, no later than 90 days from your last work, you must record your lien. You can record your lien while you are working. You don't have to wait 90 days. You don't have to wait 80 days. You can record it the day after you finish your work. You could record it in the middle of a job. We had a client come to us who was owed several $1 million. He was not going to stop working. He was going to finish the job, but he wanted to exert a little extra pressure. So we recorded a lien for him as he was working, ongoing, for the money that was owed. And that was enough pressure brought to bear on the contractor and the owner that they paid him that amount because the lien affected the financing of the job. So don't think that you have to wait until you're done. You can record a lien while you are working. A couple of things to keep in mind. 90 days is not 3 months. Again, you have 90 days to record. Some months have more than 30 days. Some months have fewer than 30 days. So you need to remember that in your calculations. And also know that with respect to the notice to owner, it has to be received by the 45th day. So if you send it through SunRay or you do it yourself, just know that if you put it in the mail on the 43rd day, it may get there on the 46th day, and that notice to owner will be no good. So you need to send it early. We typically recommend sending that notice to owner no later than from when you first start work. You can send it as early as when you sign the contract. You cannot serve your notice to owner before then. So for example, let's say you are a subcontractor and we just finished a meeting and I tell you, okay, you've got the job. You can't serve a notice to owner yet. While someone may have told you you have a job, you technically don't have a contract for it. Now, let's say a week later, I send you a contract, you sign it. So now it's officially your job. You may not show up for another month or two. You can serve your notice to owner once you have a contract. And if you don't have a contract, because sometimes it's such that you don't have a contract, but you already start working. Once you start working in the field, providing materials and labor to the field, that's when the 45 days officially starts to run. So you want to start the count no later than from when you start work on the job. Back to the last work for the claim of lien, know that last work does not include repair, punch list, or warranty work. So it has to be real work that entitles you to be paid. So it can be base contract work that's not complete. It can be approved change order work that is not complete, that you finish. Passing an inspection does not by itself constitute last work. So for example, if you show up today to finish all the work on the project in order to pass the inspection, and then you call the inspection, and a week from now you have the inspection and you pass, for last work purposes under the lien law, it's today when you did the work, that's your last day. It's not a week from now when you actually pass the inspection. So passing the inspection is nice, but that is not last work under the lien law. It's the day you actually do real work. And again, approved change order work can extend that deadline. Just remember that while you think you may go back to the job, if you never in fact go back to the job, you may run out of lien rights. So I'll give you another example. Let's assume that you're owed some money on the job. The job stalls a little bit. Maybe the owner has some financing issues. Maybe there's permitting issues, plan revision issues. And you say, you know what, well, I'm going to be back on the job, in a few months. And, that's when I'll deal with this problem. And then 1, 2, 3 months go by. It's now past 90 days. And guess what? The job shut down. They terminate you for convenience. No one's going back to the job. If your last work was more than 90 days ago, you will have lost your lien rights. So keep that in mind. The fact that you may have more work to do does not extend your lien rights. It's reset every day you do work on the job. So next step, step 3, no later than 15 days from the recording date of your claim of lien, you need to serve it on all interested parties. That typically means the owner, the contractor, anyone that's listed in the notice of commencement. If you have SunRay handle your lien preparation and filing, they're going to send it to everyone anyways, but that's a requirement as well, that it has to be served within 15 days so everyone gets a copy. Step number 4, if you have a direct contract with the owner, you need to serve what's called the contractor's final affidavit no later than 5 days before you sue on the lien, which is step 5, which we'll talk about. We typically recommend that if you are required to serve a contractor's final affidavit in order to perfect your lien rights because you have a direct contract with the owner, that you do it when you do the lien. So if you're preparing the lien and you're a GC, prepare and serve the contractor's final affidavit at the same time. Check both of those boxes so that you can not have any other hurdles that you have to jump through to enforce your lien rights. The contractor's final affidavit is only required for those that provide labor and materials, or just labor. So a GC needs to serve a contractor's final affidavit, but a contractor's final affidavit is not required for suppliers, people that only provide rental equipment or supplies, or professional services like architects or engineers. So if I'm an architect and I have a contract with the owner, I need to follow all the rules I just mentioned, but I don't need a contractor's final affidavit. If I'm a supply house and I provide plumbing supplies and my contract was direct with the owner, I need to follow all the steps we just talked about, but except number 4. That's an exception. The suppliers and professional lienors don't need a contractor's final affidavit. And then the last step is no later than 1 year from your last work. Sorry, no later than 1 year from the recording date of the claim of lien, you need to file a lawsuit to foreclose on the lien. That means you have to hire a lawyer. You have to file a lawsuit in civil court to enforce your lien rights. You don't have to wait a year. You could do it within days of recording your claim of lien. And that's very important to keep in mind, that you don't want to keep waiting. You should likely consider pursuing your lien rights sooner rather than later. If you wait a year Or if you wait, there's no such thing as extending the lien by re-recording it. I hear people say, well, I'll just record another copy of the lien. No, you cannot do that. The only way to keep that lien alive after you record it is to file a lawsuit to enforce that lien. Now, these rules are very complicated. We've made a handy desk tool. It's called the Lien-O-Matic. We send it out for free. If you go to lienomatic.com, put in your information, you'll see a little video of how it works. You keep it on your desk. And to the extent you have any questions about all the rules we just talked about, and plus many, many others related to the lien law, it's right on your desk. It'll give you the answer very quickly, lienomatic.com. And we'll send you one for free in a few days. Oh, let's go through some bond claim rules. So a payment bond secures your right to be paid on a job. So where we typically see this is on either public property, because you don't have lien rights on public property, like a public school, public hospital. The government requires that the contractor get a bond as the protection because you don't have lien rights. It can also be on private property. So we typically see this on larger multifamily projects where the lender is going to require the owner to get a bond to make sure that the property is kept free and clear of liens. How do you know if the job is bonded? If you look at the notice of commencement, which is the document that is recorded by the owner at the beginning of the job, if the job is bonded, it will reference it there, and a copy of the bond is recorded with the notice of commencement. But again, if you use SunRay to do your notice to owners, they're going to do all of this research for you, and if the job is bonded, they will send out the necessary notice in that regard. You can also find it on the project. It's supposed to be posted with a copy of the permit and the notice of commencement. So that's typically in the job site trailer. All right, so let's go through the steps. You're going to see they're very similar but not identical to the lien steps. So step one, you need to serve what's called a notice to contractor no later than 45 days from your first work on the job. Now, this is similar to the notice to owner. It's not identical. You've used SunRay. They use what's called a combined form, which is the notice to owner for liens and the notice to contractor for bonds, and it's all one document. Now, this is only required if you are not in privity, if you don't have a contract with the bonded contractor. So for example, if we're on a public project, the contractor has a bond, they hire me as the plumber. Well, I am in privity with the bonded contractor, so I don't need to serve this notice to contractor. I recommend that you do. Again, our advice is any job over a certain amount, whether it's $500 or $2,500, you pick the threshold. You just notice all of those jobs. You don't determine, well, I don't need it here, but I need it here. You just say, you know, for every job over this amount of money, we're going to send a notice to owner. That's what we see our best, most successful clients do. Step two, you need to serve a notice of non-payment within 90 days of your last work. This is, again, like a claim of lien. It's a document prepared with certain information about what's owed, signed and notarized. This is not recorded like a lien. It's just served in the mail, certified mail, to the contractor, owner, and surety. You can still serve this notice of non-payment while you're working, but it must be served no later than 90 days from your last work. Remember, just like the lien rules, 90 days is not 3 months, and last work rules apply. So it doesn't include repair work, punch list work, or warranty work. And then the last step is you need to file a lawsuit in court within 1 year of your last work on the job. Remember, in the lien claim, we said it's 1 year from the recording date of the claim of lien. Here, it's 1 year from last work. So there's a little difference between those two rules. So don't think that, well, for my bond claim, I have a year from the time I serve my notice of non-payment. That's not the rule. It's 1 year from your last work. And again, this is the outside-most deadline. You can do it sooner. We have this other handy tool. It's called the CalcULien. You can go to calculien.com and we'll send it to you. It helps you calculate the 45 days for the notice to owner and notice to contractor, as well as the 90 days for the claim of lien and notice of non-payment. So go to calculien.com, fill in your information, and we'll go ahead and send you one in the mail so you have it on your desk so you never have to count with your fingers ever again. All right, so let's go through some collection tips. Collecting on accounts receivable is a necessary evil in every business. So what are the best ways to do it? So you should do it verbally and in writing. You got to make phone calls. You got to send emails and text messages. You need to be nice, but be firm that you need to be paid. The squeaky wheel gets the grease. Our most successful clients that use us the least because they get most of the work done themselves are the ones that have a aggressive and firm collection strategy in their office. You want to try to negotiate with the actual decision maker, meaning if there's issues on the job, you're negotiating some amount of money they want to credit, you want to make sure that you're talking to someone that has the authority to make a deal. So if you give someone a discount, 10% discount to pay, we'll take 90,000 instead of 100,000. Let's make the deal. And they say, okay, well, let me check with my boss. I have to get back to you. It's very frustrating. So make sure that if you're doing that, you're dealing with the person that has authority. Consider using joint check agreements. This is especially true for suppliers. If you have payment concerns, you can get a joint check agreement in place. What is a joint check agreement? It is a written promise. Usually we see it from the contractor to pay either a supplier directly or a subcontractor directly. So typically we see this as an issue with subcontractors. So the supplier or the sub of that subcontractor has payment concerns, and what they do is they enter into a joint check agreement with the GC. So it's a three-party agreement signed by the GC, the sub, and the supplier. And what it does is it says every time that a payment is due, that payment will go from the contractor over the sub right to the supplier. Now, what's important is you need to understand that it's governed by its terms. There's no standard joint check agreement. So you have to read it, and whatever it says, that's what's going to happen. Now, just know that if you are being asked, if you ask for a joint check agreement and the contractor is the one that prepares it and gives it to you, that joint check agreement may have a lot of protections for the contractor and not as many for you. So just make sure that you read it. And if this is something that you have to deal with on a regular basis, consider having your own joint check agreement prepared so that you can hand it out. Understand that the joint check agreement typically requires that that middle party, the subcontractor, has to endorse a check. So you want to make sure that your joint check agreement either says, or you have a process in place that if that joint payee, the subcontractor in my example, refuses to sign the check, that the contractor will issue a single party check to you. Because otherwise that subcontractor can hold everything up because he or she refuses to sign that joint check under the terms of the joint check agreement. Consider giving credits on prompt payment, but don't give unconditional credits based on verbal promises. So what do I mean? You want to avoid, let's go back to my example. I owe you $100,000. We agree that I will pay you $90,000 so long as I pay it in the next 2 weeks. I tell you, please send me a credit memo for $10,000. If you send me an unconditional credit memo, meaning credit memo $10,000, if I don't pay you within those 2 weeks, you've still issued the credit memo because the credit memo wasn't conditioned on prompt payment. So you want to add language to your credit memo or to your correspondence that says this credit is expressly conditioned upon the undersigned receipt of payment of, in this example on this PowerPoint, $10,000 by May 25th, 2026 in cleared funds. Otherwise, this credit memo is void, right? So you want to condition credits on the payment because what you want to avoid is you want to avoid a situation where you've given someone a credit, They didn't pay you. Now you have to proceed with collections, and you don't get you've given the credit. It's gone. You only want to give the credit if you actually get the money. The folks that get the highest return on their collections are those that secure your lien rights. That's why we went through the whole set of lien rules, so you understand how they work. Don't delay in initiating the legal process. We are able to do a much better job for our clients collecting their debts when they come to us early versus, oh, Alex, I've recorded a lien. I'm coming up. It's been 11 months and 2 weeks, and I need to proceed on this lien. And I say, okay, well, tell me about it. And, oh, well, the project manager that was running that job, he's no longer with us. And yeah, we migrated our accounting system, and not all the documents are intact, right? So we see that the passage of time affects the ability to collect as well as we'd like to be able to collect. So we recommend hiring a lawyer and filing a lawsuit as soon as reasonably possible after you have exhausted all of the other available avenues to you to try to get paid yourself. And with that, we are done. Jesse, do we have any questions?
Well, first of all, Alex, thank you so much. You are always so wonderful and insightful, so I appreciate it. We do have a couple of questions that have come through. The first question that came through, it says, can I include my attorney's fees and filing fees in the amount of the lien?
So we recommend, the answer is yes, but not like you think. So we recommend that in the lien amount, you only put the principal amount. So if the amount that's owed for the work you've performed is $10,000, that you lien for $10,000. And the SunRay lien and most liens that we see just say, it also says $10,000 plus interest and legal fees or collection costs, right? And the reason that it says that is that interest is continuing to accrue, so we don't know what that number is. And legal fees, you may have some or you may have a lot. So as long as you have the placeholder by reference in the lien, that's all you need to do. We recommend only including the principal amount in the lien.
All right, perfect. Thank you so much. The next question that has come through, it says, is monthly service work lienable?
Yes, so long as it is not generic maintenance work. So I can think of an example. So lawn and landscape maintenance, right? If that's what you mean by monthly work, that's not lienable. Preventative service where you're actually not doing work on like an air conditioning system. You show up, you clean a filter, that's generally not lienable. Now, if your monthly service work turns into real work to improve the property, permanently improve the property, then the answer is yes. But I would need to know more to be able to tell you whether or not the exact thing that they're talking about is or isn't lienable.
Of course. All right. Thank you. Another question that came through, it says, how do you collect your lien and collections fees here in Florida? What verbiage needs to be written into your subcontractor's agreement to protect your legal recovery of your expenses?
So in Florida, the prevailing party on a lien or a bond claim is entitled to recover their legal fees. So if you record a lien and you win, you are entitled to your legal fees at the discretion of the judge. So, take that for what it's worth. Sometimes they'll give you some of it or all of it or none of it. It's up to the judge. But you have that right if you have a lien or a bond claim and you prevail. If you have a contract, that contract needs to say that the prevailing party is entitled to recover their legal fees from the non-prevailing party. So having language like that in your contract, in a written agreement signed by the parties, gives you that right under your contract as well. So you just need a prevailing party attorney's fees provision in your contract that's signed by the parties.
Okay, wonderful. And then another question that came through, it says, to confirm, if you are under contract finishing up a job doing punch work, you cannot lien if you are past the 90 days.
90 days from the last time you actually did work. So meaning you've only been doing punch list work for 91 days and now you want to lien, the answer is yes, you probably are out of luck on your lien rights. That being said, I would say it's worth investigating a little more. Sometimes we find clients that think they only did punch list work and we feel comfortable enough that maybe some of the work they did in between could extend the 90 days. But if we're just doing an academic discussion about lien rights, then yes, if we're clearly past the 90 days, unfortunately, no. If you record a lien after the 90 days, that lien could be considered invalid and fraudulent, potentially exposing you to having to pay the other side's legal fees.
Okay, wonderful. I think that that's all the questions that have come through. There was one more question, and I will address it myself. It's asking if this webinar will be sent to you, to the registrants at a later time. Yes, that is correct. In a few days, once the video is available, you'll get an email with that information. All right, are you able to get it? Perfect, thank you. So these are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. There's project information sheets, all sorts of really good stuff that will help you kind of make sure that you are on top of what you need to know as far as information on that project at the beginning of that project or that contract, so that way you're better protected. The next slide, please. All right, here are our next webinars with Alex. It's I blew my notice to owner and lien deadline. Now what? That's going to be March 19th at 10 a.m. And then the next one after that will be stop, don't sign that release unless it says this. That's April 16th at 10 a.m. We'd love to see you guys there. Please register for free at sunraynotice.com/education. Hopefully you can make it. All right, if you are going to be in the Palm Beach area, we are going to be hosting our next in-person seminar with Alex and Ariella speaking to you both. It will be a really great event, Lien Law Waiver and Release Masterclass. So please get signed up. The location will be on our site within the next week or so. So please check back for that at sunraynotice.com/seminars. And then the next slide, if you don't mind. All right, if you don't mind, give us a really quick review on Google. We really appreciate it. It helps us better the content and information that we're getting out there to you, and it helps get the word out to other contractors like yourselves. All right, and then the next one, if you don't mind. And with that, that is all we have for you guys today. Thank you so much to everyone that attended. We hope to see you at our next webinar. Alex, again, thank you so much. You really are incredible. I hope everyone has a beautiful and sunny day. Thank you all.